Hello everyone. Welcome to today's webinar session hosted by Chettinad School of Law on Juvenile Justice System in India. I am Shanmusundaram and I am currently pursuing my BLLB Honours at Chettinad School of Law and I will be your moderator for this session. It's such a pleasure to introduce our guest speaker for today, Professor Dr. DrRThilagaraj. Thank you so much for sparing us time from your busy schedule, sir.
Thank you.
I would like to briefly introduce Dr. DrRThilagaraj. Professor Dr. Thilagaraj has vast teaching and research experience over 4 decades and administrative experience over 2 decades. His specialization includes diverse areas such as cyber crimes, cyber laws, juvenile justice, community-based treatment of offenders, restorative justice, human rights, victims of crimes and abuse of power. He is currently the chairman of Excellence in Justice Education and Research in Chennai and Center for Excellence in Digital Forensics, Chennai. He was the former professor and head Department of Criminology, University of Madras. He was director, Center for Cyber Forensics and Information Security, University of Madras from the year 2012 to 2014. Sir has also been a member of different committees in University of Madras. Professor Thilagaraj has received many prestigious awards including Career Award by University Grants Commission under Career Award Scheme for Young Scientists for faculty members in the year 1995 and Dr. B.S. Hekkerwal Professor Sushil Chandra Award for Senior Social Scientist and he has also received many other awards. Dr. Thilagaraj has completed several international assignments such as being a visiting research fellow to University of Mecca and visiting fellow to Department of Criminal Justice, Illinois State University, USA. He was the vice president of Asian Criminological Society and member of several organizations and universities across the globe. Sir has also worked as visiting professors at various national law universities including Gujarat National Law University and National Law University, Lucknow, and other reputed universities in the country. Sir has published 10 books, more than 70 articles in professional journals, and 30 textbooks for university students. Apart from this, Sir has also made academic visits to different countries across the globe, including USA, Germany, Brazil, and many other countries. We are so honored and happy to have you here with us, sir.
Thank you.
I would now request Dr. Shamtanu Paul, Associate Professor, Chettinad School of Law, to welcome the esteemed speaker of the day.
Good afternoon to one and all present. Special afternoon to Thilagaraj sir. We are very happy and very honored to host you today for this webinar session. It's indeed a privilege for us to hear from you. Firstly, we would like to apologize because we could not do justice to your legacy of teaching, education and all that experience that you come in with. However, we tried our level best to compile and give a brief outline of your legacy of teaching. So on behalf of School of Law, I welcome you once again, sir, and we are very eager and very happy to listen to you and gather lots of knowledge from your lecture today. Thank you very much, sir.
Thank you. Good evening to one and all. I am so happy to have this opportunity to deliver a webinar speech on juvenile justice in India, on which I have been working for the last 2 decades. So teaching and projects also. And I would like to share my thing now, and then we can go ahead.
Sir, excuse me, sir. Before we proceed, I would like to briefly introduce Chettinad Academy of Research and Education and Chettinad School of Law. The Chettinad Group, with legacy over 60 years, have been pioneers in providing a progressive learning environment across Tamil Nadu. They are currently responsible for over 12,000 students in 22 private, government-aided schools and colleges for medicine, dentistry, nursing, engineering, law, physiotherapy, architecture, allied health sciences, and pharmaceutical sciences. Chettinad School of Law is recognized by BCI and approved by UGC and that provides high quality education through active learning methods and with experienced faculty and exposure through legal internship. School of Law is member of IUCN Academy of Environmental Law and International Association of Law Schools.
You did not change the sign or the multiplication should not become defined. Right? So you can get visualized what these kind of going to this.
Before handing over the session to the guest speaker, I would like to tell few pointers to the participants of this webinar. Everyone is requested to kindly mute your audio. There will be a feedback form which will be sent by us in a while through the chat box. Everyone is kindly requested to fill it. There will be a question and answer session at the end of this webinar. You can send us your questions through the chat box. You can even send us the question during the middle of the session. Thank you. The floor is all yours, sir. You can proceed.
Thank you very much. Once again, I welcome all the participants of this meeting. I would like to give my speech on juvenile justice in India. Initially, I will give an introduction, then I will explain to you the origin and development of the system globally, and what was the position in India prior to independence, what was the position after independence, and what is the present position. This is how I'm going to explain to you this lecture. Now, in the beginning, you see, in the beginning, there was no difference between adult and juveniles treated offender, both of them, both the offenders, young adult, were treated equally. There was no difference. But in the mid 1800s, separate system for confining juvenile offenders emerged, so that they should be segregated. They cannot be kept along with adults. That will create problems. And in 1899, the first juvenile court was established in Illinois, USA. That was a juvenile court movement, they say. This is the beginning of the juvenile justice system in the world. And the juvenile delinquents, the concept has three assumptions. One is three historical developments that led to the concept. One is the discovery of the childhood and adolescence. You know that in psychology, there is a developmental psychology that explains the human development from birth, and it made into three levels: childhood, adolescent stage, and adult. And again, it is further divided into early childhood and late childhood, early adolescence, late adolescent, early adulthood, and late adulthood. This psychological development and further research in this developmental psychology made it that maturity of the children is juveniles are very less, and so that it cannot be compared with adults. So that in treating the juveniles in the criminal justice system, they cannot be equally treated. They should be differently treated. They may not be able to understand the consequences. To that extent, they are immature enough. That is what the development psychology explains about childhood. The second one is juvenile justice system was founded on the belief that parents picture. It is a legal concept. It's a noble philosophy. Originally, this parents picture principle, the doctrine was taken from the King's Court from England. The king is the father of the people, father of the citizens. He must take care of the children. He must take care of the citizens. He must responsible for the welfare of the citizens. And the same principle was given to the juvenile courts, that the parents patriarch. The purpose is whoever working in the system, whether it is a juvenile court magistrate or any police or in the correctional institution, all through from beginning to end, they must consider, they must think that it is my child. This child doesn't have good parents because of broken home conditions, some problems. Now it is the responsibility on the part of the state that you must take care of the child. It is not sympathy, it is empathy. For a moment, think that it is your child, and what will you do if the child is deviant, if the child becomes delinquent? That should be the approach, and that's why we insist that parents mature all through the juvenile justice system, that from the beginning to end, all the stakeholders in the system must keep it in mind and work with the children. Then comes the emergence of positive school of criminology. Now, there are two schools of thought. One is the classical school of thought. That was the beginning. There should be a law, and the law should explain, oh, these are the crimes and these are the punishment. Only if there is a punishment, there will be a fear of punishment, a deterrence, and it will prevent crime. That was an approach. It concentrated more on protecting the society against crime, so that society is important and it least bothered about the criminal. Now, the emergence of the positive school of criminology paved a way for a scientific criminology, understanding the causes for the crime. And accordingly, you have to think of reforming the delinquent or the criminal, so that there was a shift from crime to criminal. This shift made to probe further, understand the development of a scientific criminology. And this scientific criminology made it very clear. You must, you must first of all understand. It is like diagnosis and treatment. Understand the causes. Accordingly, you treat the delinquent, a child. And when you treat a child, you must understand, you must, it should be individualized treatment. Each child has his own problem. He comes from a different family background, different neighborhood. So that understand him accordingly, you have to design a method of treatment. So that understanding the causes, accordingly you have to design. That is objective. Now there are three R's specularly for any rehab, any treatment of the children. One is reformation, rehabilitation, and reintegration. Reformation is understand behaviorally why he has committed. Is there any problem, psychological problems, any sociological, any social problem at home, at neighborhood, so that understand for him. Then accordingly, you should try to reform him behaviorally. Then he might have changed behaviorally, but you must change him economically. You must go back to the society, get a job, so that you must give him some training in a trade or commerce, so that rehabilitate him economically, so that reform him behaviorally, rehabilitate him economically. Finally, he should be reintegrated into the mainstream of social life like anybody. When I say reintegrated, you did everything in the correctional institutions. But when he comes out, the society should accept. He must be re-assimilated as a member of the accepted member of the society. That is called reintegrating into the society. So that these are the basic principles. These are the base on which the entire juvenile justice system is working throughout. So that there are legislations later, but all these legislations with this background only, they all designed for the welfare of the children. So that all through it is a welfare approach, a child welfare approach. What best he can do for the child. He has come from a family background, a social environment. Now it is the responsibility of the state to reform him, rehabilitate him, and make him a good citizen. That is the objective of the juvenile justice system. Now we will go through that. What was the position in India before independence and what and after independence? In the beginning, it was under British colonial rule, so that whatever the the act that was there in England that was applied in India also. The first one is the Apprentices Act. We technical people go for apprenticeship training like that. Here also the children, so that they should not roam around on the streets. They should not be left out that like that, because an idle mind is devil's workshop. So that the children, the wayward children on the street, and the children who are unable to get proper care from their parents, they should be taken care of by the state, and they should be given training so that they will be getting a job or employment. Then naturally they will be refrained from committing any offense. In 1860, the Indian Penal Code also made it that under 7 year, uh, the child above 7 and 12 my understand his understanding is 8 above 7 and under 12 they don't have the maturity, so that you should keep it in mind. And again, in the 1990, the All India Jails Reforms Committee, Lord Macaulay was asked to examine the prison conditions prevailing then in India throughout the country. He examined and he brought out a report, Jail Reforms Committee report in 1990. One of the important recommendations he made was that many children were there in the prison and they should not be kept in the prison along with the adults. They should be brought out. There should be separate homes for the children. Apart from that, you must have a legislation exclusively for the children. And according to then the act, that time it was presidencies, Madras Presidency, Bombay Presidency, and Bengal. All the three have enacted their own Children Act. The first one is the Madras Children Act. According to this act, the state should provide for the care, custody, trial, welfare, education, character training for youthful offenders, and also uncontrollable children, destitute, other children need of care and protection. So this was the situation before independence. Then there was a Reformatory School Act was established in, and that schools were certified school, approved schools. These schools were exclusively to reform the children, the delinquent children. And the criminal procedure code also provided a provision that the young offenders, instead of sending them to a correctional institution, they should be reformed within the community. A community-based treatment called probation was also, there is a provision in the criminal procedure code. Like that, there are three legislations, Presidency 1920 Madras Children Act, 1922 Bengal Children Act, and 1924 Bombay Children Act, based on the recommendation that report of jail committee by Lord Macaulay. Now, after independence, what was the position? So that three presidencies have had their own Children Act. Now, each state, after the independence, many states, each state had their own Children Act. For example, the Madras Children Act was followed by states in South India, so that we have Tamil Nadu Children Act. And apart from the State Children Act, there was also a Central Act, Federal Act, Children Act 1960. This 1960 Act is exclusively meant for union territories. But some of the states, they don't have a proper Children Act, so that the government asks you amend your Children Act according to the Central Children Act. But the problem was there were Children Acts all the states, but it was not properly implemented. Apart from that, there are variations. For example, definition of the child, maximum age, minimum age, some states 14, 16, some states 16, 18. There were a lot of discrepancies. And above all, the act, some of the states had the Children Act, but they have not implemented the Children Act. Wherever it was not properly implemented, the children were sent to prison. Just imagine the children are kept in the prison. They have to undergo all kinds of the problems with the adult prisoners. This situation has become still more worse. So that Thilagaraj filed a case in the Supreme Court. And when she filed a case, Justice Bhagavati of Supreme Court asked for a detailed report from all the states, so that each judge, the district judge, should go to the homes for the children, and he must collect, compile the statistics as how many children are there in the homes and how many children are in the prison. What is there? Is there any juvenile court? If the juvenile court is working, is it working in line with the Children Acts? So that the Supreme Court asked for the data, complete data from the district judges, and the data provided by the state government through this district courts, it is really the situation was so alarming. Many prisons had children. Children were not in the homes. The reason is the Children Acts were not implemented. Some of the states, particularly Bihar and UP, most of the children were lodged in the prison. The reason is the juvenile courts are not working like a juvenile courts. They were all working like a criminal court for adults. So that the concept of juvenile court, what we have discussed, we don't find with the juvenile court. As a result, children were forced to get into the prisons. So that Thilagaraj filed a case against this, and Justice Bhagavati made an order that all the Children Acts should be replaced by a single legislation, Juvenile Justice Act 1986. This is the first time uniform single legislation. It is not only that, it is the act was framed in line with the beating rules, that is United Nations standard minimum rules for administration of juvenile justice. So that the welfare approach of the children, the delinquent children, particularly in India, it has reviewed, revamped through the Juvenile Justice Act 1986 after the Supreme Court judgment. So that this Act 1986 was, it is a breakthrough in the history of juvenile justice in India. So that the Act made it very clear, first of all, no child should be sent to prison, no child should be dealt with the adult criminal court, no child will be sentenced to life sentence or death sentence. All the children should be dealt under the Juvenile Justice Act, and there is a court, juvenile court. The act explains who is a juvenile and who is a juvenile delinquent and who is a child in need of care and protection. This was the Juvenile Justice Act 1986. This Juvenile Justice Act definitely it paved a way for a better position of the children in India. Now, all through this approach towards children was child welfare approach. Welfare is the paramount important in the administration of the juvenile justice. But the state should not think it child welfare is a favor to the child, and it is a right of each child. The child rights movement, particularly the UN Convention on the Rights of the Children, we as a signature, as a member of the UN, we have to accept. We have amended the act in line with the UN Convention on Rights of the Children. Now the Juvenile Justice Act 2000 and 2006 it was little amended. This act was again forced to amend. This act uniformly made it that child means anybody who is below 18 years, boy or a girl. Whereas in the earlier Children Act, there was a difference between, in the case of a girl, it is 16, in the case of a boy, 18. Whereas this act made it very clear that all the children, a child means below 18 years, and all the children below 18 years will be dealt with under the Juvenile Justice Act 2000. And this act explained that there are two kinds of children: the children in conflict with law. Earlier in the previous acts, juvenile who has committed an offense, who is a delinquent, contrary to this act, that should not be a stigma for the child, so that it made it very clear children who come in conflict with law. Now, this act also changed that the police should be there completely. There is a change in the police approach towards the child, the judiciary, and also in the correction. There should be a police exclusively meant for dealing with the children. And now the no more juvenile court, it is, yeah, juvenile justice board. However, this code, this act was excellent one. It was, it include all the rights of the children. It was prepared in line with the child rights. However, there was a crime, a serious crime, a rape case known as Nirbhaya case, Delhi gang rape. A sensational crime happened in Delhi. All of you aware of that. That forced to make here amendment in the act. This Delhi gang rape case, one of the offenders was a child, 17 and a half year old boy. He involved in this. And there was a hue and cry, because when the offense was committed, when they were all arrested, there was a different kinds of approach. There's the adult offenders were taken to the prison, whereas the child was taken to the observation home. It should be treated like under the Juvenile Justice Act. He cannot be compared with the adults, and this was the situation. But there was hue and cry. There was protest all over the world, all over the country. I think if you could see the scene in the India Gate, people, many people, big crowd protesting against this kind of incident. And this boy should be hanged to death. This boy should be treated like adult. He should not be treated under the Juvenile Justice Act. That provision of below 18 years as a child should not be given, because it is a serious crime. It is a heinous crime. Naturally, he should be differently dealt with. So that there was a need for this amendment. And apart from that, there was one more case in the, that was apart from this case, there was another case. that is Salil Bali versus Union of India. So that here, uh, Justice Altamas Kabir, he dealt with the case, and there were 8 petitions, writ petitions in the Supreme Court against this act. This act should be amended, and these young people, these children below 18 years, 16 to 18, should be removed. The act is very serious in nature. It threatens the society, and they should not be given lenience, and there should be it should be removed, and they should be sent to prison, and they should be dealt with under the criminal code. This is the crux of the petitions. There are eight petitions, but among the 8, 2 of them are in favor that this the history of juvenile justice is very soft all through. So that it's a long history. All of a sudden, you should not change. Their contention is the juvenile delinquency. If you see the statistics, it is 1% in the overall crimes in the country. Among the 1%, the juveniles who committed such heinous crimes, seriously, it may not be even 0.2%, considering that you want to change that. So the difference of opinions, difference of ideas were put together, and finally the judge Altamas Kabir made it very clear it cannot be accepted as such. However, there was a change in it. In the meantime, to amend the criminal law, particularly for the offenders who committed the rape, a committee was appointed by Justice Verma. Justice Verma completely gone through all the materials, psychiatrists, neurologists, ex-legal experts. They all were as advisors to give their suggestions to amend the act before amending. It was a voluminous report. We go through the report. They have made it very clear that in the beginning I told you that the developmental psychology made it clear the maturity of the child is very important. As such, children below 18 years is not mature enough. Remember, it is not just, it is not here. There in the developmental psychology also, they have conducted a study. Now here, apart from the psychologists, psychiatrists, there are neuroscience experts. They are also of the opinion a child means definitely below 18 years. 18-year-old a boy cannot be compared with an adult because the nervous system is not mature enough or grown up to reach that adult stage, so that it should be treated like a child only. So that all experts in the field suggested that we cannot change. Child means child, it should be 18 years, so that all the experts, scientists of the view that scientifically we have to accept it, that despite that the offense is serious. So that so many petitions like this, and there was the report also made it very clear. So that finally, the will of the people is above all. So that naturally we have to make it change. So that there was a provision, a special provision for children between 16 and 18 years who have committed a serious offense were made in the 2016 Juvenile Justice Care and Protection Act. But this again, as I told you, the act has not lost its sight of rights of the children. The rights of the children, it should be the base for framing this law, Juvenile Justice Act. So that whatever we had in the Juvenile Justice Act 2000, it is there as this, except these changes, amendments for the offenses that have been serious in nature, heinous in nature committed by children below 16, 18 years. So that certain principles should be followed while implementing the Juvenile Justice Act. Juvenile Justice Act must have the basic principles enshrined in the UN Convention on the Rights of the Children. What are the principles? The principle of presumption of innocence. The child is innocent child. He is not mature enough. That should be considered the first or most important while you take into consideration at any stage child. The next one is dignity and worth. You must give him dignity. You must provide him. At no part, no way, the dignity, the self-esteem of the child should be affected. So that he must also, like your child, he must be treated with dignifiedly by all stakeholders, whoever it may be, from the police at the end of the correctional people, and there should be a participation. The child should feel I am also part of this community. I am accepted. Just because my poor conditions, I should not be segregated. I should not be the society should not show me a inimical approach. So that participation very important. And I know all the best interest, whatever the best possible on the part of the possible on our part, we should give it to the family responsible principle of family responsibility. This is very important. So that, as I told you, the parents' patria, the parental role. So that it's like a parent, he is a part of your family. So that whether at any point of time in the process, the family is unable to provide you the required needs, the psychological and other needs of the child, so that it is the responsibility of the state, and the child should be protected. Safety is very important. As you know that most of the time these children are abused by the gangs, all the criminal gangs. You know, even 2 days back, there was a theft in the bank. A child was used with the hope that if they are caught, they will escape because he is a child. So that but behind the child, there was a gang that forced him to operate and escape. So that once the child, the child will give the evidence, whatever happened. So that safety is very important for the child. So that always it is the responsibility of the system to provide safety and security. All the positive measures should be for the welfare of the children. Principle of non-stigmatizing semantics. This is very important. Just because he is in the from a home for the delinquents, because still people think children are coming from the minor jail. He's a he's a criminal. He's a convict. Once a convict, always a convict. This labeling had very bad impact on the children. Criminology, we have a labeling theory. This labeling again and again made an impact on the individual personality of the offender. Probably he may be first offender. When you label him and again, he will change his personality that have impinge on his uh, self image, that will, so that people, principle of non-waiver at any cost. These are the rights. You cannot waive rights. Principle of equality, non-discrimination. Because he comes from a poor family, because he is a underprivileged, no chance. You cannot discriminate. You should treat all the children like all the children. And principle of right of privacy and confidence. Whatever the child has committed, he might have committed the offense. At any point of time, it should not reveal it because it affects the future of the child. That is very important. So that privacy is very important as far as the child is concerned. It should be confidential. Principle of institutionalization as a method of last resort. So that as far as possible, try to restore with the parents. Parents are the best people, but then there is no alternatives. You can send them instructor. There are many alternatives we will discuss. principle of repatriation and restoration, restorating with a normal life, accepted life with the family, with the community. That is very important. So that when the child comes from or the system, from the police, from the court, again go to the correctional institute, when he goes back, he must start a new lease of life, a fresh start. And apart from institutionalization, there is no need for institutionalization. There are many more diversion programs that the child should be given the natural justice. That is very important. With these principles only, the Juvenile Justice Care and Protection Act of 2000 was designed, and with little amendments because of this offenses committed by some of the juveniles in the age group of 16 to 18 were made. The objective of the act in general is apprehension, detention, prosecution, penalty, and imprisonment. It was not there. And now this, because of this amendment, even imprisonment has come. Rehabilitation and social integration of the children in conflict with law. So that these children should be finally reintegrated into the mainstream of social life. That is very important. Procedures, and the decisions, and all the orders related to the children should be towards rehabilitation, adoption, reintegration, restoration of the children need of care and protection. What is the current position under the Juvenile Justice Act 2016? The Act is made it clear. Meaning as a child, a juvenile or child is a person who has not completed 18 years of age. Juvenile in conflict with law means who is alleged to commence an offense and not completed 18 years of age. A child in need of care and protection means your homeless children, beggar children, many children. But in my discussion, I am going to concentrate only on juvenile delinquency, juvenile in conflict with law alone. The agencies, these are the agencies involved in the juvenile justice process to achieve the objective of reformation, rehabilitation, and finally reintegration. All these agencies is a responsibility. They are the stakeholders, the police, the Juvenile Justice Board. You know, earlier in the Juvenile Justice Board, it was juvenile court. As I told you, this is a Juvenile Justice Board. Then the probation officer, there is an observation home. There is a children homes exclusively, as I told you, children other than this delinquent children, the children who are in conflict law, not come under the children homes. And special homes exclusively for the delinquent children, reforming them and rehabilitating them. There are special homes, and there are aftercare organizations, that is after release from the correctional institution. Let us see one by one their role, each one's role in the administration of the juvenile justice. Now, under this act, when the act was amended in line with the Convention on the Rights of the Children, the act made it very clear the police has a role. The police also should be different. Although the police can not treat a child who come in conflict with law like an adult criminal. So that the police are trained. The police are trained in child psychology, child welfare, and they are elected as a child welfare officer, so that each police station has a child welfare officer in each police station. And at the district level, there is a juvenile police units. And this juvenile police units also supported by 2 social workers. Again, the police did not behave like other criminals, so that the social workers help the police in the noble job of reforming the children. When the police apprehend a child who is coming conflict law, he must completely prepare a report on nature of offense. Remember, it is not first information report, it is report. So that a report on nature of the offense, his family background, about his parents, his economic background, whatever the best possible, and his part he must collect. And the police should inform three people. First, the parents. You must inform the parents that the child has committed an offense and it is with us, and we are going to take the child to the juvenile justice board on this date, this time, and you please come to the juvenile justice board. And also they should inform the probation officer. Probation officer is one who is working in the community, so that not all the children are sent to correctional institution. There is a alternative to treat the child within the community, and the probation officer is responsible for this. So that this probation officer is informed at the moment actually the word is used when the police take charge of the child. Even each and every word in the juvenile justice has a meaning, that no way it should impinge on the child that I am a criminal, I am different. So that is each and every word is very carefully given in this. So that the probation officer in charge of that area, from the area from where the child hides, he must immediately go to the place, his home, meet the parents and neighborhood, and he is completely collect all the information, so that all the social fact, completely everything all about the child he should take. Right. Then he is given, and in the when the child is taken, the child cannot be kept in the police station for more than 24 hours. The child should be taken to the observation home. Observation home is like remand, keeping the remand prisoners or under trial. Till the case is finalized, the child should be kept in the observation home. Remember, it is an observation home. So that in the observation home, these homes have a psychologist. So apart from the probation officer report, the psychologist also observe him, conduct the test, give a report. The very important part of this act is no child can be sent to a lockup or a jail, no handcuff, training, or ticker. These are the very important aspect on the part of the police. So the police should behave friendly. Remember, when the police take the child to the juvenile justice board, should not go in uniform like a police. Again, the child should not feel I am taken by the police as I have committed a crime. So that it should go in a mufti. But in the case of uh, serious crimes, we can file a FIR, but no FIR shall be registered for non-serious crimes. If FIR is registered, a copy of them should be available to the child and his parents. And when the child is kept in the police station, that is 24 hours, we should provided food and other medical facilities if required. At any situation, the police should not compel the child to confess the crime. Parents should be present during the interview of the child in the police station. Police should take immediate action against the perpetrators who exploited the children, who made him to this vulnerable situation of committing a crime. That is what the police should do. Police should also inform the district legal services authorities. The child comes from a poor family. He is not in a position to defend, so that it should be the free legal aid should be available for the child. No torture or cruelty to the child at any point of time, at any circumstances, by the police against the child. And the police officer should forward the report of the probation officer to the Juvenile Justice Board. This is how the police should work. So that the child, the approach of the police completely should be different from a crime committed by adults. Releasing on a bail. A child who has committed an offense, whether it is bailable or non-bailable under this act, he can be released on bail, except the offense if it is committed a serious crime, then it cannot be. All otherwise, in all other crimes, the child can be released on bail. However, it need not release on bail. As I told in the beginning, if you are part of the gang who should have committed a crime, so that the moment the child comes out, that will endanger the life of child. So that as long as possible, till the final decision of the Juvenile Justice Board, the child should be kept in the observation home. Now the Juvenile Justice Board comes. Originally, it was a juvenile court, as I told you. This juvenile court, originally, it was only with the legal people, the magistrate who was in charge. But in course of time, what happened? This, if you see the 1986 Juvenile Justice Act, there will be legal people, a bench consisting of one or two magistrates or one magistrate, it depends. But he is assisted by the social workers. The social workers help the judge, so that the magistrate, the judge should be provided information completely about the social background of the child by the social workers. They should help the child. But what happened in course of time, these judges, they never consider the social workers suggestions. Finally, now there is a bench, one legal person, a magistrate, and two social workers, and one of them should be a woman. So that it is called a hybrid bench. This bench is a hybrid bench. This is not like ordinary court. It is a social legislation for the welfare of the children, what best possible you can give. So that the child has committed a crime, fine, that's over. Now what best you are going to do for the child, the best interest of the child, how you are going to, you must plan. The justice board is like a planning board. You must plan what best, individualized treatment. Each child has his own problems. He comes from his own family, or family, different family. Police, some of the countries, I had been there in China for a project on juvenile justice in Asia. I have gone through the material. I compared with the China, India, and other two countries. I found that in Japan, the police, whatever we talk about the correctional institutions, whatever we talk about the community-based treatment, are completely taken over by the police in Japan. That's entirely different. Child-friendly police, we talk, but it is, we in practice, we find in the Japan. So that it is not the Juvenile Justice Board, juvenile court. It is a family court where the children, the parents, and the neighbors, they all come. They all discuss in the family court, and they even coming to the family court also. Last, as far as possible, the policeman, when he try to do something better for the child, otherwise he is taken to the family court where it is decided like a family member. That is the situation. The board expected to function as a bench. It is very important. As I told you, the legal person who is a judge cannot take a decision on his own because the approach is different. So that it is a joint decision. It is a, it is a bench, a decision of the bench. They consult with the social workers and what best possible, the best interest of the child is the paramount important in the decision making of a juvenile justice board. So that the approach of the approach, what's how the juvenile justice board approach in decision making for the betterment of for the best interest of the child. First of all, toward rehabilitation as far as possible. How to rehabilitate child, how to reform him in the formative years. There is something wrong in the families. You fill the gap. That is the big deal. Rehabilitate him. What kind of education you give, what kind of trade you can give him. Finally, he should go back as a citizen, as a member of the society. That should be the plan that the Juvenile Justice Board should make it. I want to mention here one of the renowned criminologists, Marvin Wolfgang. He was a renowned criminologist from Pennsylvania State University. He was a professor of criminology, professor of criminal law, and professor of sociology. He was interviewed once in the BBC, and they asked, Professor, tell me when we call it in criminology, the onset of delinquency, when a child became a delinquent. And the professor answered, I was on the streets. I was an orphan. I haven't seen my parents. Somebody picked me up, adopted me, given me a good education, good life. I am a professor today before you. Had I not been given that opportunity, probably I should have landed up with the gangs on the street. I should be in the prison. So that this is how he says that it is the family, the many factors, social factors that makes an individual criminal or non-criminal. It should consider while taking decision following what are the circumstances under which the child committed an offense, understand the profile of the child, causes, the consequences of the offense he has committed. What is the role of the parent? What are the role of the peer group, the friends in committing the crime? If there is a gang, how? And socio-economic condition of the family. And above all, what should be the future plans of the juvenile? Remember, the Juvenile Justice Board should plan the future of the plan, occupation, the interest, occupational. You should decide. You are going to send the home. There are many trades. What kind of trade it can be given? What education you should give? It's like a planning board. I can say Juvenile Justice Board is not just punishing, punishment, something like that. It's like a board which takes care of the children. Regular discussion with the probation officer. That is very important. Probation officer is the community. He knows what happened in the community, why the boy has committed the crime. He completed a report. We call it a pre-sentence investigation report. So that he investigated. Police officer investigated about the crime, whereas the probation officer collected complete information about the background, family background, community background, environment, completely to have a complete understanding about the child. And as I told you, it should plan. The board should plan. I told you the board is, it's a hybrid coach. It's a different kind of coach. So that it should discuss along with the social worker what appropriate individual and rehabilitation plans applicable for this child, individualized treatment. And apart from that, the members of the homes, the juvenile justice board should visit the homes meant for rehabilitation of these children. As I told you, there are observation homes, there are special homes to interact with the staff and the children. And particularly, it should pay the special attention to the girl children. This is the final order after considering the report from the police, report from the probation officer. If necessary, if there is a psychological problems, that psychologist attached with this institution, you get the report of the psychologist. So that everything is there before you. Social facts provided by the probation officer. Psychological facts provided by the psychologist. And there is facts about his offense. Now you do whatever the best possible on the part of the child. You go through that as far as possible. Try to restore with the parents. Nothing can be equated with the home with the parents. And with your warning, you can send him back. And direct the juvenile to participate in group counseling. Group counseling is very important, so that you can have a psychologist, have a group counseling, bring them. As I told you, that the child feel participative. When you make them participative, it feels I am recognized, I am part of this community, I am part of this society, I am taken care. So that in a group counseling, you must give them. This group counseling will have, all kinds of children, good children. The children themselves are familiar with your counseling. So this is how I am good, this is how I am bad, this is I am affected because of my deviant behavior. So in a group counseling, along with the psychologist, will help the child to understand his position on his own understanding. A retrospect, he will understand. Send him for community service. This is very important, because one of the findings in criminology, the people who have a bond with the community, who have a commitment to the community, will not commit a crime. So that in the countries where there is a commitment towards the community, less crime. So that send him for community service. I tell you one case. It happened many years back. The judge is called Chocolate Judge. A girl child who has committed a theft in a shop. He was taken to a juvenile court. The judge given a punishment. The punishment is, you should go and work. You must buy the chocolates. You must give it to the poor children in your own area. And later he has become a renowned social worker. So that this is sent him for community service, so that he will understand the situation. If possible, pay the fine. Ask the parents to the fine is the crime, and he can be taken back by the parents. Two very, very important things. Release the juvenile of probation officer, compiles the report on all the social facts about the child. As a last resort only, the juvenile justice board should send him to the special home. As far as possible, try to restore with the parents. The other alternative is release him on probation. Probation is a community-based treatment of offenders. All over the world, it has been experimented beyond doubt. It is not necessary all the offenders should be sent to prison. As students of law and criminology, you might have studied Sutherland's differential association theory. You will go there, and if you send him to the prison, he comes back as a learned criminal techniques. He learned all techniques, technicalities. So that try to release him on probation. Probation is a community-based treatment of offenders. So that even if you send him to the home institution, he must come back again to the same place, to the community from where he hails. So that probation is been accepted, proved beyond doubt this the best method of community based treatment. But I am very sorry to tell you, probation has been proved all over the world. It was very well experimented in India in 70s, but today I think some of the social workers also there in this meeting, they will tell you that the probation is completely neglected subject. It is not necessary. The first offender who is committed because of the unfavorable circumstances, if you send him to the institution, he will learn all kinds of crime and criminality. He will come back with all kinds of techniques. You want to send him for that? So the best way is treat him within the community. Community-based treatment. Probation is a community-based treatment. But remember, probation is there is an exclusive act 1950 as Probation of Offenders Act exclusively for this. Despite this act, despite there is a pressure, I'm very sorry. If you ask many of the probation officers that the judiciary is still reluctant to release the offender on probation. But the probation of offender acts make it very clear. As far as young offender is concerned, try to release him on probation. And if you don't release him on probation, if there are grounds to release him on probation, if you don't release him on probation, you must give the reasons why you are not releasing on probation. So that probation is the best method of treatment accepted all over, but still, we are lagging behind. It was 1976 was, we celebrated year of probation, the National Institute of Social Defense. So that at the time, all the judges, police officers, all the stakeholders were given training. What is probation? What is the usefulness? How is it effective instead of sending a person to the prison or the institution? And as a last resort only, you direct the juvenile a special home. It is a special home again because it was certified school, it was reformatory schools, but in the people, if you go to the village, they will call still it is a minor jail meant for the children. That is kind of label and stigmatization still prevails, and so that it is a special home. In this home, you will find all kinds of programs. This special home, remember these special homes, there are guidelines. Along with the Juvenile Justice Act, there is a juvenile justice rules framed by the government. It is a bare act, whereas juvenile justice rules make it very clear what are the things that a judge should consider at the time of a decision. What are the things a home must have? How the personnel working in the homes work towards, so that it completely gives a guidelines. So in the special home, you have a regular school education. If he drop out, he continues his education. If he is not interested in education, he is little bold, he will be given a training in a trade. So that facilities are the skill training, skill in a particular trade, so that when he comes, as I told you, that he must be rehabilitated economically. For that, he is giving a training. And sometimes in these special homes, even after completing the tenure, if they want to study further, they are provided. I know some of them join as a polytechnic diploma, they studied IT also, and when they come out, they are we get a placement, so that economically they are rehabilitated. Now, as far as whatever we have discussed so far is the children who come in conflict law, who have not committed a serious crime, but there is, yeah. All through this act was soft approach. Of course, in some of the countries, it becoming tough to some of the children who have committed serious crime, particularly in India. This after the Nirbhaya case, there was an amendment, and this amendment, there is a specific method of dealing with the children who have committed heinous crime. Now, there are two already. There is an assessment made by the probation officer, the investigating officer, so that now the heinous crime committed. Now, the act says, as far as possible, try to deal with him, the heinous person who has committed his heinous crime, within the ambit of the Juvenile Justice Act, not try to send him to the adult criminal court or prison. That's why you completely have a group of experts, psychologists, social workers, other people, completely study about him once again, so that why he has committed, what is his background, his probation officer report of the investigation, and what are all the factors that resulted to commit a crime like this. The complete assessment is necessary. Once the factors are completed, now again this board has got to decide whether this offender should be referred to the a court that is called juvenile court, that is an adult criminal court where the child should be sent, and completely the child will be dealt with under the criminal procedure code 1973. Again, the witnesses and all kind of uh, uh, inquiries will be there, and based on the assessment of the juvenile justice board, it takes that decision. And remember, this children court also again, once again, it makes another assessment. It don't take that just like that assessment. It again, because it's sending a child to the court and sending the child to the prison. It is not easy, but it is a serious one. It's serious repercussions. So that as far as possible, try to release him on probation. Let him undergo a treatment within the community. But you must go at, you must completely probation. You must understand probation is a conditional suspension of sentence. With it, you have committed a crime, you are convicted, but we are not sending to the prison or correction. Instead, we are leaving you in the community with the hope that you reform in the community itself. You will be supported by the social worker. You will be supported by the probation officer, so that we are giving a chance to you reform yourself. This is the best method of treatment. But when the conditions are violated, he'll be taken to the prison or correctional institution, so that as far as possible, release him on probation pretty dinner. So that this child, when the child, there is a second assessment by the juvenile court, where it works like adult court. So that when you conditions, you are release him, and continuous assessment is there, so that it is reported then and there to the juvenile court. But the child cannot be sent to a prison still he attains the age of 21. Suppose the monitoring authority evaluating him then and there, his behavior continuously, whether it is in the prison, whether in the special home, it should be kept in a safety place, neither with the children nor in the prison. Both of them will affect the child. That's why it should be kept in a safety place according to this act. But the monitoring authority, the evaluating authority, suppose he comes with a report that there is no change in the child's behavior, and he also attains the age of 21, then he will be sent to the prison till he completes his period of punishment. This is how the children who have committed the serious crimes, the heinous crimes are dealt with by the children court. It is a new inclusion in the Juvenile Justice Act all through. The Indian juvenile justice is, it's a soft approach all through, but I think it is a little dark mark in the juvenile justice system. Because as I told you, that is 1% of the people, the juvenile delinquency is 1% in the overall crime rate. And even that 1%, the violent crimes like this, maybe 1 or 2%. So that an act like this, sending him sometimes that misuse, abuse of the authorities also in the future. That is one of the views. Now, rehabilitation, I told you, rehabilitation, reformation and rehabilitation starts in the observation home. The moment that when the police takes care of the child, it cannot keep in the police station for more than 24 hours. It should be kept in the observation home. He is observed there. He is observed there. And from there starts rehabilitation. There itself is a decision that there is a possibility of planning what best we can do for the child, whether he is released on probation at the community, whether he is going to be sent to the special home. So that in the observation home, all this report gives a complete picture of what best we can do with it. So in the observation home, after the court takes a decision, the juvenile boards take a decision, it may be, as I told you, there are alternatives. It may sent back to the parents, release on probation, or it can be sent to the special homes exclusively meant for the children who come in conflict with law. So that community-based treatment, as I told you, probation is the best method. Apart from all this, prevention is better than cure. There are prevention studies prove that most of these delinquent children who come in conflict with law comes from the slum neighborhoods, and these areas there are boys clubs they are there, run by the police in Chennai, 2 or 3 boys clubs, so that the energies, the time should not be wasted by the children, so that purposefully they utilized, they are given games, and the school tuitions are taken by the volunteers for the children. That's why the boys clubs are working very well. They can play times, they have study time. These are the boys clubs provide. Another one is child line, so that anybody who come across any child, whether it is child is abused, when any other delinquent child is abused by the gangs, this child line will be immediately contacted and the rescue, and they will provide the best possible. This is how the system works, the juvenile justice system works in India. Thank you so much, Sanmaga Sundaram and my friend.
Thank you so much, sir. Thank you so much for this valuable presentation, sir. We would go for this question answer session now. I could see many questions are pouring into the chat box. As per time concerns, we would select few selected questions. So the first question I would like to address to is, what is your opinion on place of safety? Whether institutions like place of safety in India are properly implemented?
Can you repeat it?
Yes, sir. Yes, sir. What is your opinion on place of safety? Whether institutions like place of safety in India are properly implemented?
This place of safety is
Place of safety is mentioned in that, but the people who are working in the homes for the children, they are also not clear. Do you know what happened in Tamil Nadu? There is an observation home in Willow. That observation home is made as a home for safety, safety place, so that these children are kept in the safely in that place. That is what happening.
Yes, sir. Thank you, sir. The next question is, why juvenile commits heinous crimes? What can be the main reasons?
Yeah, I think better you.
Yes, sir. Why juveniles commits heinous crimes? What can be the main reasons?
The main reasons, there are many reasons in criminology. I taught in the class, there are many reasons. One reasons, many factors. The factors that make an individual as a criminal. Many factors, peer group, family background, neighborhood, or the parent-child relationship. There are many factors. It is for a individual, sometimes psychological factor. One factor, what the current situation is, the media experience a very different kinds of violence. I tell you, some 20 years back, there was a research that media has no role in crime. Then after 10 years, they found yes, the media has a role. 50% of the crime, that is a relationship between media and crime. Today, media produced crimes. So that if you ask, don't ask the child, yes, I have learned from this movie, I have seen this in the TV. So that the movie is one of the factors, one of the factors. This is one side, the other side is parental control. Parental control is what we have seen yesterday, 30 years, we don't find, that's one of the reasons previous crimes, stimulating crimes, particularly sexually stimulating sceneries you could see in the media, what I told you. An adolescent boy, you see any program in the TV, I tell you, it's just even for a Horlicks we find, he must eat like anything, he will get a strength. He must carry Horlicks. That Horlicks he will strength. Like that, everything, all the advertisements are like that. Two things, either, sexually stimulating for adolescent or becoming a violent. This is the two things. After touches tomorrow, all the advertisements. This is how it is one of the reasons. So it was found that the children they spend most of their time in media, and media is not regulating agency or healthcare oriented agency. Instead, they learn a lot from the media. Next.
Thank you, sir. The last question is the current infrastructure support in India is sufficient to rehabilitate and reform juvenile delinquents?
Yes, it's a good question. And I think we have made many criminal justice reforms, as I told you, from the day of Lord Macaulay after independence. There was a reckless and idiot what the reckless in India here examined the correctional. There are the Parliament report, Professor Menon report. Many reports are there to reform the criminal justice. Literally, they made an attempt at correct. Now, juvenile justice, after independence, only the Supreme Court, Justice Bhagavati made it that should be completely reviewed and the revamp the system. And afterwards, now this biography, after there is, but completely there is an evaluation, a research should be conducted on what is the position of the juvenile justice system, how, what are the gaps in it, how it should be improved further. Because it appears to be neglected something. There is a need for it. Lot in the politics, not in the human rights perspective. What is happening in, like for example, I tell you, we tell a lot about the police, the separate police officer, police spirit is there, and how far it is implemented, how far it is accepted by the police. It's a big question. So that there is a need for evaluation. What are the objectives? How it should be implemented? What is the there is evaluation required for the juvenile.
Thank you so much for your valuable input, sir. I would now like to invite Ms. Ruchi Sinha, Head of the Department, Chettinad School of Law, to share her thoughts about this session.
Thank you, Sundar. And on behalf of entire Chettinad School of Law and entire team who has worked for this, webinar, and also all participants who have been wonderful listeners and audience, I extend our sincere thanks to Professor DrRThilagaraj. Thank you so much, sir, for giving an excellent coverage to this juvenile justice system in India. And you have pointed out certain things which kind of struck a chord with everyone here. And yes, we do think that yes, whatever points you have addressed is very important and is the it's actually the need of the hour which we have to discuss upon and how to improve upon. Thank you so much, sir, for that. And thank you so much for being here this evening, taking out time from your very busy schedule. We know you are very, very busy, and also it has been a great pleasure, sir. Thank you for answering the questions. There were so many questions which were pouring in, so we couldn't take up all the questions. But in future, maybe yes, whenever we collaborate, we'll take up all the other questions as well, sir.
Thank you so much.
Thank you so much, sir.
Thank you, ma'am. Thank you, sir. That brings us to the end of this webinar session. Thanks to everyone who has tuned in. Do tune into a future webinar session. I would also like to thank Mr. Sibi from LMS for recording this session. That brings us to the end. Please take a look at our website and other social media platforms like Instagram, Facebook, and YouTube for the information about the upcoming session. Till then, stay home, stay safe. Bye.
Thank you.